This is Paul. Just looking at the protection order right now. hmm Certified copy? Yeah. hmm I was arrested multiple times for violating the restraint provisions. Let's go ahead. The police and sheriff's departments had the evidence that I wasn't in Squim right now, but they decided to say I was incompetent. Pooch. Now, let's look at how do you issue a bill of attainder right now. Hmm? You can do it without the restraint person. Oh, without the protected person being there? Yeah. hmm You can take it upon yourself as a judge to issue bills of attainder without any actual judicial process. Now, I'm thinking that this violates the full faith and credit of every state, but it also violates what's known as the judicial process necessary to issue a court order or bill of attainder. Now, a lot of attorneys are going to sit back and say, well, is it? Is it really a bill of attainder? Well, let's look at it, Brent, right now. Let's see here. Service. Yeah. Clallam County Sheriff's Office. Where the restrained person lives, which shall personally serve the restrained person with a copy of this order? Yes. But it wasn't the sheriff that served me. It was somebody else in the Squim Public Library. Poo poo. You served someone other than myself? Yeah. The acknowledging the receipt of the copy of this order, the restrained person didn't have a sign there. Yeah, that's where I would have signed it. And this presented by protected person. Yeah, she didn't actually present it. No, she didn't request it from the court. No, somebody impersonated the protected person because it was not presented by. The protected person didn't present this in court. It looks like a bill of attainder. It really does, Brant. Now, when you use forgeries to issue these, is that Superior Court Judge Brent Basden? Yeah. Well, that's not your actual signature. Hooch, hooch. And then no acknowledgement as a receipt of copy of this order of the petitioner? No. No due process to the actual respondent? No. And then somebody else filled this out when it says the petitioner or the petitioner's lawyer shall complete the law enforcement worksheet? Yeah. And then there's a forgery of the ex officio Superior Court clerk? Yes. Now, it looks like a bill of attainder. Yeah. Now, since it wasn't the sheriff that served me, no. It looks like the fraudulent, yes, use of return of process. Yeah. That the sheriff's department right now has been issuing bills of attainder. Bill. Now, let's just look at it for a second because it looks like that's what this is. Yes. Restrained person is ordered above. The court found on page 1 that the respondent did not have actual notice. That's what it says. Ouch. There was no opportunity to be heard. No. See, you just use number 9. Yes. Court will review upon motion of respondent. Protection of the minors. There's no exclusive continuing jurisdiction. Yeah. There was no civil subject matter jurisdiction to issue the first one. The second one on July 6th. Oh! The next one in 2013, August of 2000. No! There was no actual jurisdiction of law. Now, petitioners granted. The respondent will be allowed visitation as follows. No contact until there's a mental health evaluation of the respondent and treatment if recommended. Now, let's look at, July 8th of 2011, August 12th of 2011, yeah, May 31st of 2012, right, July 6th of 2012. Modifications in October of 2012. I found this interesting. That my sons were taken, yeah, without any subject matter jurisdiction of this state to be able to issue this. And then my wife was going to get child support from me, yes, of $81,615, yes, without any judicial process. Pouch! Right now. Grand larceny. Now, for all the complaining that I do, yeah, I just want to mention something because I found it somewhat disconcerting. Yes. This idea of visitation. Did you mean kidnapping? Oh, because in the state of Pennsylvania, it seems that an individual similar to myself was not allowed to actually talk to, yes, their own child for 20 years. Yes. Now, in this case, let's see here. Communications Commission, FBI, however, ACLU, side by side victory of the Supreme Court of the United States. Constitutional rights of minors, Unconstitutional Reform Act. Now, CAN-SPAM, Federal Trade Commission. Yes. Don't let the bed bugs bite down and dirty justice. Now, the attorneys in the state of California, the 6068. Yeah. Let's see here. In 1996, the U.S. Congress passed the Elizabeth Morgan Act. Yeah. Dr. Elizabeth Morgan, being the mother of Hillary's, also known as Ellen Morgan, a child born to her and Dr. Eric Fortich, yeah, whom she has been accusing of child abuse for the past 20 years. This bill denied Fortich even supervised visitation with Hillary. Yeah. On December 16th of 2003, the U.S. Court of Appeals for the D.C. Circuit Court, D.C. Circuit, yes, ruled that Congress had passed an unconstitutional bill of attainder by denying even supervised visitation where no abuse could occur. The legislature had labeled him a sex offender and punished him as such. Fortich versus the United States. As Hillary is now over 21, this ruling is mute, but it does raise an interesting question. If under separation of powers, punishing individuals is the judicial function. Now, would not, to adapt Brown's language, the executive exercise of the judicial function, or more simply, trial by executive, to which Star Chamber proceedings, be just so bad? Except, if so, how now administrative tribunals? Yeah. Now, this U.S. Court of Appeals, yeah, the Morgan Act, and in 1996, yes, Dr. Hillary being the mother of Hillary, yes, child born to her and Dr. Eric, yeah, whom she had been accusing of child abuse for the past 20 years. The bill denied Eric Fortich even supervised visitation with Hillary. Now, you wanted me to motion the court for visitation, even supervised visitation.